Good morning and greetings on the day before Thanksgiving 2023. To all the friends of the law offices of Brent Williams-Ruth, I say happy Thanksgiving. I am grateful for you and for taking the time to watch this video. Now, this video is provided as an educational discussion for those who are residents of the state of Washington. And the topic is to trust or not to trust. That is, should you and your family have a revocable living trust in Washington state? Short answer is no, you should not. Okay, now let's go and give some nuance to that. All right, so many people call my office because somebody somewhere has told them that they need to have a living trust or revocable living trust for their estate planning. Now, I will acknowledge and concede that more than half of the country live in states that have substantive state laws that make trusts, especially the revocable living trust, the preferred estate planning method for that jurisdiction. Washington is not one of those states. All right, let's start to unpack that a little bit. Let's talk about the state of California. In the state of California, you have Prop 13. That dramatically changed estate planning because, again, homes that are inside the trusts are then not subject to a adjustment to market rate property taxes if it just passes along to the next person in the family but never leaves the family trust. Washington doesn't have Prop 13. There are also rules regarding child support obligations about if you pass away and you have an estate that is not in trust, that you have to pay out the remaining child support obligation. Washington has no such law. Florida has a law that actually charges attorney fees based off the size of the estate if it's not in a trust. Washington has no such laws. In fact, in Washington, if somebody charges you to administer an estate based off the size and value of the estate, you should call the Washington State Bar Association and file an ethics complaint against them because that's unethical. Mostly. Again, there's nuance. But it's just not the way it's done. In Washington, we don't say, oh, you've got a $50 million estate. I'm going to charge you $62,000. We don't have those kind of schedules or fees. Other states do. Now, let's talk about the estate tax. Putting your estate into a revocable living trust will protect you from having to pay the Washington estate tax if your estate is over the value of the exemption amount. Wrong. No, it will not. There is zero tax protection for a revocable living trust in Washington state. Let me say this again. Zero tax protection. Okay. Now, let's talk about creditors. Oh, I want to put everything into a revocable living trust because it'll protect me from creditors. No, that is not the truth. Quite frankly, the easiest way to protect yourself from creditors in Washington state is to have appropriate levels of insurance, such as an umbrella policy or excess coverage lines that will shield you from any liability where people won't be able to go into your own personal assets. As a former insurance defense attorney, that is what I endorse. Putting things into trust thinking that someday you may have a car accident or some liability, no. And again, there are trusts that can protect you, but not the standard revocable living trust. The easy one that everyone talks about. Washington doesn't have those laws. It's not the way. All right, now let's talk about a con. So you come to me and you are in the prime of your life and you are a high net worth earner and your taxable income tax rate is the very top of the tax bracket. Congratulations for you. Well done, well deserved, well earned. All right. But now you go to retirement and you don't need as much and life has changed. And so you then have everything in your trust. Guess what? Trusts are taxed at the highest tax rate, regardless of the amount of money. So if your trust earns income, say through dividends or distributions that are taxable as income, because it's paid to a trust, you will pay the highest tax threshold. Now, many of my clients who have been at the highest tax rate during their earning years have a lower tax rate in their non-earning years. If they had their assets in a trust, they would still be paying that highest tax rate. So, these are just some of the examples. Oh, let's talk about the big one, probate avoidance. Probate is like the stepchild that nobody loves, but it's not their fault. Probate is actually a wonderful, wonderful little stepchild that should be brought in to the big table and given a big hug, because probate is not the problem. The Washington State Legislature decades ago went through and streamlined the probate process. For estates that are in order and you don't have to wait to file the Washington estate tax return, even if you have a taxable Washington estate but not a taxable federal estate, estates like that, they can be opened and closed in 5 months. My own mother, who passed away in February 2023, modest estate, nothing big, was just going to my sister and I. We have a very good relationship. We worked through all of the assets and who wanted this and who wanted that. We go through the process. We went through what's called the notice to probate creditor period. It's 4 months from the date of first publication after probate is started. And once that was over, that cut off any claim from anyone being able to come back and say that my mom owed them money. Anyone that made a claim that was valid, we paid it, it's done. Anyone that didn't, they missed the window, and now my sister and I have been distributed the inheritance. All of that was done by August. So she died in February, it was done in August. Now, why did it take even that long? Because the fact that, well, my birthday was in June and I took some time, and a lot of people administer estates that way. Though you can close it very quickly, many people, for their own reasons, will take their time to work through the process. The more stuff, and again, my mom had already moved into an assisted living facility due to illness, so a lot of her stuff was dealt with back in 2021. So the amount of stuff was greatly reduced, or there may have been more time where my sister and I would have had to go through. And again, the family home had already been sold. Life had downsized. So if you are someone who's going to pass away and there's going to be the family home that people have lived in for 50 or 60 years, it may just take you time to work through and have the garage sale or the estate sale, or to donate to your favorite charity, or to call 1-800-GOT-JUNK. I don't care, but that may take you some more time. That's not the probate process's fault. Again, there are states where the probate process is terrible. For example, in Nevada, where my parents had a timeshare, to even get into court to open probate in Nevada to deal with that property there was a several month waiting period. Washington state courts don't have that. Literally, the minute you get a death certificate, I have clients that bring it to me. I open probate that same day. We have different court structures, different processes where there's no delay. People come to me and say, oh, I'm afraid we need to be able to get money to pay for the surviving spouse's assisted living or whatever. And I said, great. That money will be at your disposal in about 2 days. Can you wait 2 days? I will tell you that people are like, oh, there's a deadline. We have to pay the fee on the first of the month, and it's the 27th. I said, great. Call them up, let them know that you have an attorney, you're opening probate, and you might be a little 2 or 3 days late by the time you actually get the money from the bank. But it's not the process that will be slowing you down. So again, the vast majority of people in Washington state are able to maximize the benefits that come with a passing without having to have a revocable living trust, a well-written last will and testament. Now, I want to differentiate. If you've stuck with me this long, let me talk for a moment. If you're one of my clients that has minor children, inside your will, after that paragraph that says, I leave everything to my spouse, and that whole paragraph there, the next one down is likely the start of what's called a testamentary trust, meaning that the trust will be born out of your will if the situation that both you and your spouse are gone and you have the minor children or children that are under the ages that you've structured for when they could get their inheritance without any strings or further guidance. That is not what we're talking about. We are also not talking about family members who may be on governmental assistance. That is a need-based program where they need to have what's called a supplemental special needs trust. All of that is connected to your will. What we've just been talking about is a standalone document, generally 45 pages on up. My largest trust I've seen was over 200 pages. All of that is for people who have very specific needs. Do you own the Transamerica building in San Francisco? If you do, you likely have a trust, but it's not a revocable living trust. Again, there are a multitude of different types of trusts, and the billionaires of the world, they do not have revocable living trusts. So please, as you are getting emails from your financial advisor that may be based in another state that's trust preferred, or as you are watching Shark Tank and listening to Mark Cuban, or as you hear Susie Orman talk, please know they don't know you. They don't know what state you're in. They're talking to the vast majority of Americans that live in states with different laws. And if you're my client and you're watching this, please know that I made a choice after talking with you about what is going to be in your best interest. And that is why, for all but for the handful of my clients, you do not have a revocable living trust. All right, if you have questions or if you would like my office to assist you with your estate planning needs, feel free to give us a call at 253-285-7751. Thank you so much. Enjoy the holiday weekend. May the end of 2023 bring health and happiness to you and yours. Take care.